All right. So, being a core element of business law, contracts is one core thing that you always want to refer to, um, and it's very very important. If you have anything to do with anybody, you know, you want to spell your responsibilities or obligations, in terms of getting that thing done. There are times where you're going into a deal with someone, and maybe the person is just meant to promote, to provide finance. Maybe you're meant to do the whole job. It could be a situation where you're meant to do the same thing, like, okay, you produce something, the other person to produce something, in respect. Maybe the same, maybe as complementary. But in the whole thing, there should be a contract in the middle of all that would dictate what should be done, when and how, and provided it's going to have a terminal period. All this will be spelled out in the contract. So we now move to say, okay, so what is really a contract? A contract can be defined, in exact terms as, an agreement per se, that exists between parties. But logically here, a contract could be described as an agreement which creates obligations under the law and give rise to enforceable rights. So it's key to look at it from that perspective, saying there should be obligations in a contract, and those obligations must be stated, in the contract. Um, this you could see in several instances. Okay, you could the easiest one you will see will be for you when you go to maybe when you go to bank, or let's say even when you purchase, a SIM, it usually comes with a contract stating that this is what should be done, this is what you should use it for, this is what the kind of service that will be provided. So if any of such, is not provided, then you can pick that same contract and go to the court of law, for you to enforce, your rights, and saying, okay, so under this contract, I have this right because this are supposed to be done, and because you didn't get this, you're now enforcing your rights in the court of law. Basically, this is why you have contract, because things may go not as planned. So you now fall back to that contract, for you to get some form of how do I say it, compensation. Let me just put it that way. So when there is a case of breach and the likes, then you fall back to the contract to actually enforce your rights. So a contract may also be described as a voluntary agreement between two or more persons, which confer legally enforceable rights, duties, and liabilities on parties. It may also be described as a promise or set of promises which, if not fulfilled, may be enforced by law. So you keep seeing that part of the law coming in, because that is the end part. Like, should this party, should something not go in order, they will refer to it. So two principal elements are common to the various attempts to define or describe a contract. They are: one, an agreement; two, a legal obligation or duty enforceable by law. So what you tend to see here is the fact that it should be an agreement, saying for a contract to be a contract, it is not somebody saying, you know, this is how I want to do my things, and you just have to accept it, and we go into the deal or into the business that way. No, the fact that somebody had drafted the contract or the agreement, or it, or provided a draft of the agreement, the onus is on the other party to also say, let me have the contract, or let me have the draft. It is still a draft at that moment, because both of you have not signed. So you need to read through the whole thing. After read through and saying, okay, so these clauses, you need clarification, you've gotten clarification, you're comfortable with what is stated. That's when you now sign that contract. At the point of signing that contract, then it is now an agreement because you both have agreed to work based on the stated terms of the contract. And based on this, there are obligations that would have been stated, you know, for the person and for the parties involved, whether two or more. Their obligations would have been stated in the contract. And should, you know, things not go the normal way, like should one of the parties not doing the needful, not upholding his role, his obligation, as stated in the contract, then there is a part of this contract that can be enforced by the law. So you can now go to the court and enforce your rights based on that. So in the case of Orient Bank, Nigerian PLC versus Bilante International, 1997, Nikito BJC, as he then was, amplified and harmonized the various description of contracts as follows. A contract is an agreement between two or more parties which creates reciprocal legal obligation or obligations to do or not to do a particular thing. For a valid contract to be formed, there must be mutuality of purpose and intention. The two or more minds must meet at the same point, event, or incident. They must not meet at different points, events, or incidents. They must be saying the same thing at the same time. They must not be saying different things at different times. Where or when they say different things at different times, then they are not addendum. Note that Latin word, addendum. And thereby, no valid contract is formed. The meeting of minds of the contracting parties is most crucial and overriding factor in the law of contract. The minds must be addendum or addendum for seat. So the word addendum, is actually something that has to do with, the two parties, coming in intact or connecting or agreeing. So if they are not agreeing, then definitely there is no contract. In Okubule versus Oyebola 1990, the Supreme Court held that an agreement will not be binding on the parties to the contract until their minds are at one both upon matters which are cardinal to the species of agreement in question, and also upon matters that are part of the particular bargain. So the whole essence of this is to emphasize the part that has to do with the agreement. So there are times where somebody will draft something. Okay, take one very funny instance. I think somebody contacted me recently talking about um, a money lender, all these shark, what they call them, is this shark loan provider or whatever. They gave a loan, they availed loan to someone, and in the event that the person was not paying back, they now call this guy. You know, I'm not sure, but the guy claimed they debited him. But what that simply means is that the guy could sue that loan firm, saying, "Okay, so where did you get me, you know, involved in this contract? At what point did you get my consent, my agreement to this contract?" Because from what the guy claimed, it was not, he never at any point in time agreed to be the guarantor to this person. So if you have agreed to be a guarantor, then this is coming up. Then it's okay to enforce that part of, the contract on the guy. But in the event that the guy didn't even know about the loan, didn't consent to be a guarantor to the loan, and his account is being debited, then he has all the right to go to the court and enforce his right and say, "Look, I don't know these people. In fact, the person, even though he knows the person that got involved in this loan, he never, you know, provided any consent to say he is willing to be a guarantor. So he could enforce that part, to say, okay, so do you have any evidence to say I actually agreed to be a guarantor? If you don't, then he is not, part of the contract. So there is no contract between him and the loan shark company also. So, element of contract. A valid contract must have certain key elements. One, offer. Two, acceptance. Three, consideration. Four, intention to create legal relations. And five, capacity to enter into contracts. These are very interesting parts of any contract, that must be reviewed and enforced when need be. Now, there must be an offer. So what that simply means is we should have someone, in the whole discussion in the beginning who must have said, I am offering this part of this contract. So because I'm offering this draft of agreement, for you to now look into it with the aim, I mean, with the prospect that you're going to look into the document, into the contract or proposed contract and agree. Let me use the word proposed contract and agree to it. So there must be an offer by one of the parties to the proposed contract called the offer. So person offering, this is called an offer, while the person who is being addressed, who the contract or who the proposed contract, is offered, is called offering. I hope you got this part.
Yes, sir.
Okay, so the acceptance of the exact terms of the offer creates a consensus addendum. So that consensus addendum that you see there is the part that says, okay, so these people going into this contract must go into the contract saying, oh, I know fully well what is involved, and I also understand what the other party is going to do. At this point, we have a connection to these contracts. So this is the meeting of the minds of the parties to the contract. It's a common thing you should know. Consensus addendum. So it is a meeting of the minds of the party of the contract to the contract rather. The relationship is entered into for the sake of promise or consideration. So this is where the consideration comes in. So they're going to a relationship, nothing has happened yet, but it's about to happen. So there is a promise saying, I will do this. When I do this, you pay me this, or you will get paid with this amount. So it's either somebody is being paid or is paying the other person. So the parties must intend that their relationship will have a legal consequence. For instance, that of enforceability. So what that means when it comes to legal consequences, it means yes, we both have this document that is, binding us, to go into this contract. But again, the both of us has this bearing in mind that look, should anything go haywire, should anything go, you know, the unexpected way, or should the expected breach happen, you know, any one of us can enforce this in the court of law. So that is why, the emphasis of the enforceability is there. In addition, the law requires that the parties must have the legal capacity to enter into a contract, and the purpose of the contract must be legal or in line with public policy. Three things have been mentioned in the statement. One is the legal capacity. Legal capacity in this regard means one, there are various capacity that we want to consider, but one of those is the fact that that person or that party that is going to this contract must not, for example, in Nigeria and in, I think in common law too, must not be less than 18-year-old. So if it's less than 18-year-old, then you're just joking because that person, you can't enforce the contract on the person. Unless, yes, there are instances where you have perhaps a trustee. So when you have a trustee, then, but basically, that person must be, 18 and above. Two, that person must have his sanity, at the time he's going to contract. You can't enter into contract with someone who is insane. No, there is no contract. That means the person is not in the right thinking at the time he was entering the contract. The third part is that yes, You can't enter into a contract with somebody who is intoxicated, perhaps as in is in level of he has taken, for example, alcohol, and you're asking the person, to sign a contract. That is also not in the legal capacity. Another part is yes, the person cannot sign a contract under duress. So you this is someone who is compelled by all means to sign a contract, perhaps maybe under what's it called? Under fear that maybe he's being kidnapped and they're asking him to sign. The person can come out and say, "Sorry, I didn't sign that contract." You know, under a normal circumstances, but the fact that um, the person was under duress at the time where he signed the contract, then it won't it can enforce that part of the contract or the law to ensure that the contract is not the contract becomes null and void at the time he puts up this claim. So then it must be legal. So not all contracts are legal. Um, Considering the fact that somebody's doing a contract that should or that has to do with producing hard drugs or producing heroin and the likes. Obviously, that is an illegal contract. So, in that or that is an illegal or illicit deal. So, um, what whatever you sign to do such is not what you can enforce in the law as a contract. Also in line with public policy. So there are times where it is not legal per se, but the public policy, there's an aspect of public policy that tries to address, okay, so so is this really making sense? So the situation where it's in line, then it is good. So that's where the public policy comes in. So offer. Let's just go into the definition and we can move faster. An offer is made by a person propose terms to another person and makes communication to the effect that if the person accepts those terms, he is willing and ready to contract with him. The said proposed terms constitute the offer. An offer is the definite, clear, and final proposition made by an offeror to an offeree with the clear intention to be bound by it if accepted. So there must be an intention by the person making this offer that should this other party agree and accept this, then it's going to be binding on the two of them, and the person is willing also to start to kickstart the contract. So an offer is the final proposal that transforms the offeror's promise into a contractual obligation when accepted by the offeree. So again, note the word that at the point when it is still with the offeror, it still remains a proposed contract. But the moment the offeree, says, okay, so I'm cool with the terms of this proposed contract. I hereby sign, and the person signs. Pam, 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 pam. At that moment where he signs, this has become a contract. So it is worthy to note. There are cases here that try to emphasize instances where it is a contract, and I'm sure there should be another one that cites where it is not a contract. Invitation to treat. An invitation to treat has been described as an invitation to negotiate. So there are times where an offer is not an offer. Yes, it looks like an offer, but again, it could be termed as invitation to treat. So this is what we're looking at, you know. So it is communication that invites the other party to make an offer. So because it is not an offer, it is mere invitation at this point in time, stating that what we have at hand is just um, calling for someone to say, okay, I'm good, I want to do this. but it is an invitation to treat is not regarded as an offer. Um, Sorry, hold on. All right, so these negotiations between parties may not lead to the making of an offer by the interested party. So what this is trying to say is there are times where the terms of the offer, if it's not duly met, if it is not duly taken into consideration, this can be ruled by a court to say, oh, what you actually presented here is not an offer, but a mere invitation to treat. So we'll get to see examples of these cases. One, advertisement. An advertisement does not constitute an offer, but an invitation to treat. In the case of Partridge versus Crittenden, 1968, an advertisement was put in a periodical case, an aviary bet, which stated Bramble Finch cocks, Bramble Finch hens, 25 shillings each. A reader wrote for a hen which Mr. Partridge sent to him. The appellant was charged with unlawfully offering for sale a live bird contrary to the Protection of Bird Act. The divisional court quashed Mr. Patrick's conviction on the ground that he made no offer for sale but merely invited interested parties to negotiate. So you could see that advertisement is usually open. Yes, it may look like an offer that come and buy this. So, but technically, what that still means at that time is that because it's an open statement, it's an open call. Yeah, let me put that way, it's an open call. It is merely an invitation to treat. So the moment that person comes up and say, "Oh, so can you do this for me and that?" Then that is a stage where it is now being directed. And at that moment, it's becoming an offer. So please note this part. There are times where you have a case and they will tell you to establish if it's an offer. Then again, to know if it's an offer, you must know the terms that makes an offer. For example, at the point when the person is presenting that proposed contract, that person has an intent to actually enforce a contract. Because the moment you propose that, then and the other person says, okay, so I agree and I'm accepting, and an acceptance is created, then it is a contract at that moment. But in this instance, this can change. This person can still come and say, I don't want what is being advertised this way, I want it elsewhere. We'll come to see some of these examples. So we've seen one. Number two is tenders. A statement calling for tenders or that goods will be sold by tender does not constitute an offer in law. So what that means is that if you understand tenders, do you know what tenders? Have you ever experienced tenders in your workplace?
No, sir.
Okay, so technically tenders looks like what there are calls made, for example, to the public. Yes, it will form in the form of adverts. It may not be adverts. It might just be something that the organization printed and is pasted somewhere, saying there are calls for tender. So what that means is they are calling for people, for example, to send in their quotes. I sell Ashwebi, I sell books, I sell this. So you now come and showcase your profile, your business to say, we do this. Maybe the company wants to set up, or maybe the company wants to buy. Oh, let's take, for example, there's a need for a company to do social responsibility. And in the course of doing this corporate social responsibility, they want to supply books to maybe some primary school or a primary school. And they're now calling for tenders to say who are those dealing, in books. By so doing, it means they are now creating tenders, calling for tenders for people to say, I do this, I do that. So they will come in with those things. At that point,
Okay, sir.
no offer has been made. That you participated in that tender doesn't mean you are part of a contract. No, it is not yet an offer. So number two, auctions. Auctions, and the advertisement of an auction is not an offer to hold the auction. Neither does the act of auctioneering constitute an offer. It is an invitation to treat. The auctioneer has the right to withdraw the lot before the buyer accepts the bid. Have you experienced auction before?
Okay, sir, let me read it. Advertisement
Okay.
no, not really, sir, because we don't actually do adverts in our site.
Okay, so auctions, for example, are instance like take for example the common one. Let me see one popular thing that happened recently. Um, I really can't recall, but take for example, you should know Michael Jackson, and you could have an instance where somebody will say, "I have Michael Jackson's shoe." Maybe the shoe he used to do break dance, and he's presenting it to some people he had invited, to come over, to come and buy that shoe. Now, at the point where they call them, they are now going to start bidding for that shoe. Someone will say, "I want to pay $5,000." Another person will say 6,000, 7,000, 8,000, 10,000. So they keep going to a point where they get to a figure that nobody's contesting again. Then that kind of noble property or no of something of prestige value is now being sold to the highest bidder. So what we're saying here is that auctions does not fall under offer. It is still an invitation to trade because you call these people in and they are still none is I mean nobody none of them who is participating in the auction has any legal claim to say, oh, because I participated or I'm participating in the auction, then it is simply an offer to me to engage in this. No, it is not. So that's the auction. Goods on display. You're passing in front of ShopRite and you see goods being displayed in the window. They are not constituted as offer. They are still merely on display. So display of goods only amounts to an invitation to treat. So what that means is all those shoes, bags that you see that are being displayed, they are not saying they are offer at that moment. They are only trying to attract you to come and say, I would love to buy this thing. How much is it? What does it take me to buy this? So I'm seeing a Lamborghini. What does it take to acquire this Lamborghini? So this is when the real offer will now be prepared for you. But at the point where it's on display, it is merely an invitation to treat. Passenger tickets or transport. Passenger tickets or tickets for public transportation cases have always been difficult to categorize as offers or invitation to trade. The position of the law is, however, dependent on whether the ticket is considered a contractual document or not. In cases where the ticket is a contractual document, the request for the ticket is varied as an offer, and the issuance of the ticket is the acceptance. So you should know this part, saying it could be something tricky in the exam when they try to establish at what point is a passenger ticket regarded as a contract. It's only at a point where that same ticket, talks about, being a contractual document. But if the ticket is just an open ticket, no term stated on it, it is still, classified as invitation to treat. Counter offer. This is, after under offer, you should have something as invitation to treat, then counter offer. Counter offer is usually something that is usually disputable in the court of law most times. So what is counter offer? A valid offer is made upon certain terms and must be clear and final. Those terms stated in the offer must be clear and final. But these terms must be accepted for the offer to crystallize into a contract. So what that simply means is Mr. A is presenting an offer. He has stated the terms of that offer already. Now, the offeree who is receiving Mr. B, who is receiving the offer, you know, in order to make that offer to turn into a contract, he must accept that proposed contract called offer as it is. But where the person to whom the offer is made responds by varying or modifying the terms, the initial offer is vitiated and modified offer becomes a counter offer. In the case of Okubule and Oyagbola, 1990, Agbaje GSC, adopting the principle from the Treaty on Contract Petroleum, stated that a counter offer has dual significance. It amounts to A, a rejection of the offer, and two, it destroys that offer so that it cannot subsequently be accepted. Now, if you want to see or take a good example, decision where, for example, somebody wants to sell Ghana here to you, and the person has sent his contract to you via email, stating, for example, this Ghana here I'm selling, or I won't use Ghana, let me use Brazilian here. Maybe the person is in Ghana and wants to sell Brazilian hair to you, and he's telling you this Brazilian hair is going to be shipped from Brazil directly to Lagos. When it comes to Lagos, it will be delivered at Oshodi, Oshodi precisely. When it delivers this at Oshodi, you will be informed, maybe via SMS, and you need to make payment instantly. After making payment instantly, you will come to Oshodi and pick it up. This is the deal, and this is the offer. You, as your free now, you got the offer, and you're saying, oh, no, me, I will not do this. So it is only going to happen when you bring that um, Brazilian hair from Oshodi, deliver it to my doorstep at Ikorodu. That is the only time I can pay, online to say, in truth, I got what I requested for. Now, what you have done at that moment is called counter offer because, it could amount to a rejection or offer, which means the person the Ghanaian guy who is trying to ship the Brazilian hair from Brazil might say, oh, I'm not comfortable with this deal and I don't want to go into this again. So I'm rejecting this. Likewise, it destroys the offer. So technically, it has destroyed the initial offer that has been presented. So, as a general rule, an offer may be revoked at any time before it is accepted. An offer may lapse or expire or be terminated by the following circumstances. One, death of either party. If any of these parties, usually in a situation where it has to do with two people, if any of the parties should die, then the contract, might be terminated. Two, non-acceptance of the offer within the timeline or effluxion of time. So what that simply means is most times the offer are made, they usually have a cutoff time, they usually have a timeline. Let's get this thing signed the next 1 month. If it doesn't get signed, then things may have changed. So this might lead to non-acceptance. A counter offer. So this is show where the offer is also being countered. A revocation before it is accepted. So this is a situation where this person is maybe you sent this offer to an offeree and it's taking time for the offeree to accept it. And the guy is looking at maybe someone else had come and requesting for that same service. You might just say, please, I'm revoking this offer, and that's the end. So you have decided to just take it back and probably will offer someone else. Express rejection of the offer by the offeree. So when the offeree that you sent an offer to says, uh, 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 I'm not going to deal, I'm not doing this, that's an express rejection. We have intervening incapacity of one party or of one of the parties. What that simply means is, yes, maybe they went to a contract and the other party, take for example, has sanity issue or is now being proven to be an infant. Infant is those below 18. So then the contract may be terminated. Supervening illegality. So we've mentioned this before. When it is established that the contract is based on illegality, failure of a condition precedent. So when the offer is made, perhaps some condition has been stated, but there is a failure on one part or one party, as expected to comply with the contract. So this may also, be terminated. Acceptance. Acceptance of an offer may be described as the assent of the offeree to the terms of the offer as stated by the offeror. Do you understand this?
Yes, sir.
Okay, so what we're trying to see here, just like you've seen, is the fact that yes, offers usually comes with some terms, to make it like a contract. So the acceptance will only happen when the assent of the offeree, to the terms of this so-called offer, is taken into consideration and fully complied with when that person signs to it. So an offer must be validly accepted before the transaction crystallizes into a contract. So instances where the person didn't sign or maybe didn't duly has not duly signed the contract, then the proposed agreement or offer, it may not crystallize into being a contract. And acceptance must be communicated to the offeror and cannot be inferred by silence on the part of the offeree. In the case of Ini versus Fernando, 1990, it was held that for an acceptance to be operating, certain conditions must be fulfilled. The acceptance must be plain, it must be unequivocal, it must be unconditional. There must be no variance of any kind between it and the proposal. That's the offer. Is this part clear? It must be communicated to the other party without unreasonable delay. Is this part clear?
Yes, sir. It is.
Are you sure?
Yes, sir.
So there is a conditional acceptance or introduction of a fresh term by the offeree amounts to a counter offer. So this cannot give rise to a binding agreement between the parties, as the effect of a counter offer is to destroy the original offer made. So most times, like I explained, when you have a counter offer, it's basically an attempt to destroy the initial offer that was made. And this kind of acceptance now is termed as conditional acceptance. So you can see the case highlighted and probably take the time to read the case. But please, when you read this, please get back to me if you need clarifications.
Okay, sir.
So there's communication by post, there's a waiver, and there's so these I have a few exceptions to the rule of communication of acceptance. So if you have case where the communication is done by post, you can have a waiver. Also, parties may choose to waive the need for communication expressly or by implication, for example, where the acceptance takes the form of an action. So we had instances where people signed agreements online. Initially, people would sign agreements physically, but since COVID came, we had instances where people had done this virtually. Consideration. The purpose of a contract is usually to gain some benefits. Consideration is therefore of essence in a contract. Something of value is exchanged for another thing of value. The thing exchange could be an act. So when you're going into a contract, what is being promised or exchanged? It could be an act, maybe somebody has to do something. It could be a promise, it could be forbearance, or goods, or detriment, or loss, or responsibility given. The most common example of valuable consideration is money or other property, or a promise to pay or transfer same. A promise which is not supported by consideration is gratuitous and cannot constitute a basis for an enforceable contract. So there are rules governing consideration that we also need to study. So I talked about legal capacity earlier, and the infant is being defined here. An infant is a person of either sex who is under the age of 21 years. The law governing contractual capacity is born out of a social need to protect infants and may not be considered legally rational. Okay, so let's take our time to go through all this to study. You we might be going into this subsequently in the other classes. So let's see how we take this. Um, sorry, do you have any question?
No, sir, not at all.
Right. So the next class, which might also be a virtual session, hopefully it will be nice if we can have it this weekend as well. Um, I'll try and ensure it's completed. Since it's you, has always been in the session, I might need to nominate you to always help getting in touch with your other classmates or classmates. That way, indirectly, I'll be nominating you as the class governor or class captain to ensure that other members of the class are properly informed and they are always involved.
Okay, sir. Okay, sir.